Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. What's new in immigration this week? Oh, the usual. Texas versus the world. A judge in the Western District of Texas granted a preliminary injunction against Governor Abbott's law designed to arrest people in Texas and have them physically removed to Mexico without the involvement of federal authorities. And I feel like I read something about a law contemplating permitting civilians using lethal force for trespassing near the border. What a world. Also, through my participation in various litigation committees, I'm privy to the fact that many immigration groups and big firm advocates are coming together to submit many amicus briefs in the Munoz case, the consular non-reviewability matter pending before the Supreme Court. Solicitor General just filed their brief. No matter the ultimate outcome of that decision, it's been heartening to see the immigration stakeholders come together and get important amici filed under very tight deadlines. I've got four cases for your listening pleasure, as the pod excitedly enters into its 200s era. Our first case is F.J.A.P v. Garland, published by the 7th Circuit on February 27, 2024. This is a very long one about a complicated issue oft discussed of late on the pod. Circuit Court authority to review the denial of withholding of removal in withholding-only proceedings following reinstatement of a prior final order of removal. And the 7th Circuit used an acronym to protect the petitioner's identity, Mr. F.J.A.P. Right off the bat, I must note that it's always been a bit strange to me that the circuits don't do this more often with asylum cases, because the BIA does it almost always, if not always, with their asylum cases. So the identity is protected before the BIA, but then when they petition for review to the circuit, everything is public and fair game. Just another seemingly incongruent thing that I've noticed throughout the years of this podcast. So, the petitioner was removed from the United States to El Salvador 13 years ago. Upon his return, he was extorted by MS-13, escalating eventually into a $2,000 demand, with a threat that MS-13 would kill the petitioner and his family if he did not pay. The petitioner reported the threat to police and filed a formal complaint, and then went to go live in hiding at a relative's house 30 minutes away. Eventually, he fled to the United States. While in the U.S., the petitioner's cousin called, telling the petitioner that MS-13 was looking for him. Quote, then in 2015, Mr. F.J.A.P. learned that the gang had murdered that same cousin in front of his pregnant wife. The petitioner believes that his cousin was murdered because he refused to divulge Mr. F.J.A.P.'s location. End quote. Caught by DHS a few years after re-entering in 2020, DHS decided to reinstate that final order of removal from 2010, rather than just start new removal proceedings all over again, as DHS had discretion to do. Following reinstatement, an asylum officer found that the petitioner didn't have a reasonable fear of persecution or torture, but an immigration judge disagreed, and so full-fledged withholding-only proceedings were initiated. And then, while it's a bit unclear, it looks like the IJ granted Convention Against Torture protection. DHS decided to appeal to the BIA, and the BIA decided to reverse the IJ, quote, in a brief 2-page order, finding that the immigration judge's decision was based on assumptions and a series of hypotheticals, end quote. That brought it to the Seventh Circuit, which also decided to stay the petitioner's physical removal pending a decision on the petition for review. Just in case the petitioner won. And the petitioner did win. But not before a bunch of heady jurisdictional stuff was decided. First, notwithstanding the Supreme Court's Santos-Zacaria decision and Oil's own argument in this case, the Seventh Circuit is standing by its prior precedent and held here that the 30-day deadline to petition for review post-BIA final of removal is an unwaivable jurisdictional requirement and not a waivable, albeit mandatory, claims processing rule. Honestly, the panel seems sympathetic to the claims processing rule argument, but prior Seventh Circuit precedent holds that it's jurisdictional, and Santos-Zacaria didn't squarely overrule that precedent. Indeed, Santos-Zacaria did not concern the petition for review 30-day statute at all. The Supreme Court just had broad things to say about INA claims processing rules versus jurisdictional requirements in that decision. But anyway, there you go. You need a petition for review 30 days post-final order of removal in the Seventh Circuit. No exceptions. Did the petitioner do so here? After all, his removal order became final in 2010. And then the removal order was reinstated about a year and a half before this petition for review. Withholding only and CAT eligibility takes time to shake out before the IJ and the BIA, after all. The petitioner petitioned for review within 30 days of the BIA's denial of his withholding and CAT application following reinstatement of that final order, but under Second Circuit and Fourth Circuit precedent. And as once argued by Oil, but I don't think so anymore, the petition for review wouldn't be timely. Just when the time begins to run following reinstatement is quite complicated, so go back and listen to Bhaktibhai-Patel v. Garland, episode 105 out of the second, and the Fourth Circuit's decision in Martinez v. Garland, episode 186. Or don't, and forget that those decisions even exist. But under either rationale, the petition for review would be untimely here if the Seventh Circuit were to agree with the Second or the Fourth Circuit. But as I alluded to, Oil no longer stands by that argument. The Fifth Circuit has reversed itself and adopted an argument favorable to the non-citizen and reviewability. And the 6th, 9th, and 10th Circuits have also rejected the argument. It seems that even the 2nd Circuit may be reconsidering it soon, I'm not sure. Here, the 7th Circuit rejected it too. Looks like the 3rd Circuit has also rejected the argument in at least 2 unpublished decisions. Lots of statutory history and other rationales discussed in this important decision, but it's kind of boring, no? And it's really, really long. We'd be here for hours if I did all of it. Great case to read and to rely on, though, when making this argument in another circuit. That is, again, that a circuit court has authority to review the BIA's denial of withholding of removal or CAT protection, if filed within 30 days of that denial, even if it's all in withholding-only proceedings following reinstatement of a final order of removal that's been final for many years. Without going too deep into it, recall that all of this kind of starts with the Supreme Court's Nasrallah decision a few terms ago. And the Supreme Court may have said that CAT protection is not part of the removal order for purposes of factual review in Nasrallah, but neither Nasrallah nor Guzman Chavez that followed even flicked at this issue of removability of withholding of removal and CAT protection post-reinstatement, much less did those decisions overturn relevant Seventh Circuit and other circuit precedent on the issue that pretty much all existed before the circuits started to reevaluate that post-Nasrallah. Quoting the Fifth Circuit in Argueta Hernandez II, a contrary conclusion would force non-citizens to file premature petitions and have disastrous consequences on the immigration and judicial systems, end quote. Not to mention the presumption of federal court review and the fact that Congress's law expressly provided for review of Convention Against Torture orders at the CAT's implementation. The Seventh Circuit then engages in quite the complicated statutory interpretation analysis. But to summarize, as I do, quote, the plain meaning of final points us towards the conclusion that a reinstatement order does not become final for purposes of judicial review until the agency has also concluded withholding-only proceedings, end quote. All you need to know. And yet I'm continuing, because that's all well and good, but remember there's a petitioner here, Mr. F.J.A.P. Well, the Seventh Circuit sees a case. The court doesn't think that the BIA actually applied clear error review as it said it was, and instead was simply disagreeing with the immigration judge. But that's not the standard for reviewing IJ factual findings by the BIA, quote, and merely parroting the proper standard of review does not immunize the board's decision, end quote. Getting into the weeds, there were three primary issues identified by the BIA. First, the BIA believed the record didn't support the IJ's finding that the MS-13 caller demanding that $2,000 was a high-ranking officer of MS-13. But to the Seventh Circuit, not only is that wrong, but the BIA, quote, actively ignored the evidence relied upon by the immigration judge, end quote. So that's not going to fly. Particularly as it relies in part on the petitioner's credible testimony. And when an IJ makes conclusions based on a non-citizen's credible testimony, quote, that finding can virtually never be clear error as long as the testimony is coherent and facially plausible, not internally inconsistent, and not contradicted by extrinsic evidence, end quote. Quoting the Supreme Court, by the way. Nor did the Seventh Circuit believe that the BIA behaved properly in reweighing the evidence of torture. If the BIA is going to overturn a factual finding in the Seventh Circuit, it seems, it needs to point to, quote, evidence with contrary facts from the record, end quote, not simply reweigh evidence weighed by the IJ, at least when it comes to clear error torture review. All made worse by the BIA's apparent, quote, failure to explain the immigration judge's errors, end quote. To end with the final substantive quote of the decision, quote, the BIA did not explain how the immigration judge's conclusion that the petitioner would likely be tortured for having the audacity to file a police report is illogical, implausible, or lacks support. The BIA did not explain why, in a country where gangs control much of the government, an assertion which was supported in the record by the State Department's country report, an individual complaint about the gang made to the gang-controlled police would not put a target on someone's back, end quote. Quite the quote. So it's going back in a big way. Who won this monster? The Seventh Circuit doesn't note the attorneys in its day of decisions. All right, fine, I paid 10 cents and went on Pacer and saw that it's Charles Roth for petitioner. I should have known. Also, Harry Graver is listed, who appears to be with Jones Day. Seems like a lot of work was done for the petitioner in this case. Congrats to all. Judge Brennan dissented on most of it. And I've got one more thing. In a unique procedural move, at least to me, the panel notes in a footnote that the panel asked all judges in the Seventh Circuit before issuing this decision whether the court wanted to rehear the issue en banc. That is, with the full Seventh Circuit, before the decision was issued. Only 4 judges wanted to, which doesn't suffice in the Seventh Circuit to go en banc apparently, so this is the law of the Seventh Circuit. And again, it seems to be the law everywhere, in every court that's addressed it, except the Second and Fourth Circuit. While the tide does seem to be turning and the issue seems to be winning for the non-citizens and reviewability, as I mentioned here and in many of the decisions that I've mentioned from other circuits over the last year, even when the circuit court favors review on this issue, a judge seems to dissent. It seems like the ultimate landscape is a bit far from clear. It's a good bet that the Supreme Court probably takes up the issue next term. And that is F.J.A.P. v. Garland. Next is Esteban-Garcia v. Garland, published by the First Circuit on February 29, 2024. It is with great pleasure that I report that the First Circuit heard my call for cases last week. It is with less pleasure that I report that it is with a loss for the non-citizen. This case is about asylum and nexus. And actually, that's not what happened at all. As I suspected, the First Circuit's published decision website was having a tech glitch, and it seems to still be having a tech glitch. But friend of the pod and First Circuit champion Sang-Yup Kim came through with his better link and sent that to me. And of course, alerted me to the First Circuit's activity that's been occurring over the last month without me being able to see it. Lucky for us all, but really for me, this is the only immigration decision that the First Circuit has published in February during the time of the tech glitches. Thank you all for indulging me. I'm sure you are riveted by the ins and outs of circuit court watching. Anyway, Miss Esteban-Garcia is from Guatemala. She's of Mam descent and, quote, grew up in a small village of indigenous people called the Teocan in Guatemala, end quote. Apologies if I didn't say that correctly. She entered the United States without authorization in 2014 and was permitted to bring an asylum claim in immigration court. She testified and, quote, submitted written declarations from herself, her brother, and 2 cousins in support of her asylum application, end quote. Consistently across her various testimonies, it appears, Miss Esteban-Garcia asserted that she left Guatemala because a man named Tito, who she used to date, wanted her to become a prostitute and sell drugs for him and his friends. Miss Esteban-Garcia got involved with Tito when she was young and soon came to learn that this was his M.O. Sounds like a great guy. Tito brought her to a forced meeting with himself and his male compatriots. When she refused to be his prostitute and sell drugs for him, Tito's associates threatened to kill her and ruin her reputation if she didn't comply. Tito then sexually assaulted her in front of the men. She nevertheless told Tito that she would report him to the police, and so he threatened to kill her and her family. Looks like to make it stop, she agreed to do what he asked. Tito and his friends let her go, and she immediately began planning to flee Guatemala. She didn't actually report all of this to the police, though. Tito kept texting. She destroyed her phone. She fled Guatemala within days with the help of her brother who was already in the U.S. She's 19 years old during all of this. According to the affidavit of one of her cousins that she submitted in immigration court and who is apparently still in Guatemala, the men continued to look for her as recently as 1 month before her December 2018 merits hearing. Intelligently, Ms. Esteban-Garcia also submitted evidence that she was diagnosed with and has received treatment for major depressive disorder and post-traumatic stress disorder. Kind of corroborates her credibility and supports a showing that her past experience was severe. No? She also submitted general country condition evidence regarding indigenous persons, sex trafficking, and violence against women in Guatemala. The IJ denied relief and protection. The immigration judge believed Ms. Esteban-Garcia. The IJ just didn't believe that this occurred on account of her race, religion, nationality, political opinion, or membership in a particular social group. Also, the IJ found that Ms. Esteban-Garcia was ineligible for asylum anyway because she hadn't filed her application within 1 year of coming to the United States. Withholding of removal denied on nexus and some other things, cat protection denied too. The BIA affirmed. Only asylum and withholding of removal are at issue before the First Circuit because apparently Ms. Esteban-Garcia didn't really challenge the denial of Convention Against Torture protection. The First Circuit affirmed the agency. In the First Circuit, quote, to meet the nexus requirement, the petitioner must have provided sufficient evidence of an actual connection between the harm she suffered and her protected trait, end quote. Persecutors can have mixed motives, but for asylum at least, a protected ground must be at least one central reason. To the agency and the First Circuit, Ms. Esteban-Garcia's own testimony undermined a nexus finding here, quote, she consistently stated that Tito and the other men had wanted her to become a prostitute and drug seller so that they could enjoy the money, end quote. That's criminal stuff to the First Circuit, sure, but it's not on account of one of the 5 protected grounds. Ms. Esteban-Garcia appears largely to have conceded this, but she argued that she was only targeted in the first place because of her indigenous ethnicity and/or a related particular social group, which is likely a protected ground. To the First Circuit, though, the IJ sufficiently considered her indigenous ethnicity and related factors, and that mixed motive cases are cognizable. But the IJ just didn't believe that Tito and his associates really cared about any of that. To the IJ, relying on maybe less than ideal respondent testimony, it was because, quote, Tito and his associates wanted her to become a prostitute or drug seller for financial gain, which is not a protected ground, end quote. The First Circuit seems to agree, but in any event, under its deferential standard of review, the IJ and the BIA aren't getting reversed here. Neither the IJ nor BIA neglected relevant evidence or arguments, said the court. In fact, during one interview with an asylum officer, Ms. Esteban-Garcia said, probably before speaking with an attorney, that, quote, I understood that all they wanted to do was make easy money, and they like to make money that way and take women into prostitution, end quote. Then when she was asked, quote, other than the money, why did these men think they could prostitute women, end quote, Ms. Esteban-Garcia apparently stated that the men had said, quote, you have a good age to start prostitution, you are young, end quote. Horrible and disgusting, but it doesn't say anything about an indigenous or other similar motivation. Finally, to the First Circuit, the country condition evidence does not independently support a nexus argument, as that evidence shows, quote, primarily how sex traffickers target women in general, young people, or otherwise vulnerable persons, but not specifically indigenous Guatemalan women, end quote. Although to be fair, said the First Circuit, some of the country condition evidence does explain that indigenous women are exploited. I guess it just wasn't enough for Ms. Esteban-Garcia to win the day, particularly in light of her repeated testimony before the agency to the contrary, apparently. For all these reasons, the First Circuit denied asylum and withholding of removal. And that is Esteban-Garcia v. Garland. Are you tired of answering your own phones? Or of wasting your valuable time on unqualified consultations? Staffy Live is the only 24/7 live receptionist and intake service specialized on immigration law. Staffy Live specialists are highly empathetic, bilingual individuals who know how to deal with adversity, have a background in client care, and are trained to qualify callers by asking the right questions. Staffy Live goes one step ahead in only scheduling qualified consultations on your calendar and then doing follow-ups when needed. Staffy Live is giving a 15-day free trial for any law firm interested with no strings attached. To apply, visit www.getstaffy.com. That's GETSTAFI.com and click on Get Started. Make sure to put in the code FREE. Links, of course, in the show notes. This podcast is sponsored by Driftwood Capital. Driftwood Capital boasts a 30-plus year track record, transacting on more than $3 billion in hospitality assets. Since 2015, Driftwood Capital has successfully implemented the EB-5 program into their development deals, helping more than 160 families find a secure path to residency through their projects. Driftwood Capital is a vertically integrated commercial real estate firm specializing in hospitality with dedicated acquisitions, development, lending, and management divisions. Their goal is to create long-term partnerships with its network of more than 1,200 active investors from the United States and abroad, while targeting attractive returns. Driftwood's unique approach involves managing all aspects in-house, from developing renowned hotel brands such as Marriott, Hilton, and Hyatt, to managing their portfolio of more than 80 hotels in the United States. If you want to learn more about Driftwood Capital, check out the show notes. And of course, let them know who sent you. Next is Uribe Andrade v. Garland, published by the 9th Circuit on March 1st, 2024. Beware the 1st of March. This case is about particular social groups and cat protection. Mr. Uribe is from Mexico and was brought to the United States in 1999 at the age of 9 with his family. It appears he didn't have authorization, which became an even bigger problem when, as an adolescent, still a child, he became involved in the Southsider gang, began using drugs, and started committing crimes. At 19 years old, he got convicted for felonious assault, and that's what started removal proceedings, where it appears he was granted lawful permanent resident status. Excellent lawyering, I can only imagine. But also, what is the United States' responsibility to children who grew up in America and got involved with American criminal gangs, but were born abroad? A question for another day. Probably another podcast. Unfortunately, though, it appears that the die was cast and Mr. Uribe kept committing crimes, including a conviction for possession of methamphetamine in Oregon. DHS charged him as removable again for that. It appears that he has mental health issues too, because an immigration judge held pursuant to the Franco Gonzalez class action that Mr. Uribe was not competent to represent himself, meaning that he received a pro bono attorney to represent him. Through that attorney, Mr. Uribe conceded removability and applied for asylum and related relief. Too bad though, right? Does Oregon's methamphetamine definition match the definition of meth? A Ninth Circuit isomer question for another day. And another case. And definitely this podcast. Mr. Uribe asserted a fear of persecution based on his membership in the particular social group, quote, Mexicans with mental health disorders characterized by psychotic features who exhibit erratic behavior, end quote. And he's totally in this group, as the evidence in the testimony shows. Not only did Mr. Uribe argue that he feared persecution for this reason, but he asserted that he'd be tortured in a Mexican mental health facility due to how people like him are treated in those facilities. He also asserted that he'd be targeted by Mexican authorities and entities that the Mexican authorities acquiesced to because of his tattoos, including a face tattoo, and his membership in the Southsider gang. Tough case. An IJ and the BIA didn't believe that the group was cognizable under asylum law, too broad and ambiguous, nor was it believed socially distinct in Mexico. Nor did the agency see a cat claim. Very experienced counsel came in for the petition for review to the Ninth Circuit, but the Ninth Circuit affirmed the agency. The Ninth Circuit does not believe that the group, Mexicans with mental health disorders characterized by psychotic features who exhibit erratic behavior, is a valid particular social group for asylum or withholding of removal purposes. To be one, that is a particular social group, that group must be immutable, particular, and socially distinct in the society in question. Under Ninth Circuit and BIA precedent, particularity requires that a proposed social group, quote, be discrete and have definable boundaries, end quote. The group may not be, quote, amorphous, overbroad, diffuse, or subjective, end quote. And in the Ninth Circuit, quote, the ultimate question when assessing particularity is whether the proposed social group is defined by characteristics that provide a clear benchmark for determining who falls within the group, end quote. Now, as I read Fourth Circuit precedent, it's possible that particularity, that standard, is satisfied simply by writing the group's definition clearly. But more appears required by the Ninth Circuit here. Mr. Uribe argued that, in particular, no pun intended, the term, quote, erratic behavior, end quote, narrowed the group and made it sufficiently particular. But neither the BIA nor the Ninth Circuit purportedly know what the term erratic behavior means. Therefore, said the Ninth, in circumstances like this, quote, the BIA may conclude that a proposed social group is insufficiently particular when the group definition involves terminology that is undefined or unexplained in the record, particularly terminology that purports to be medical in nature, as here, end quote. Without a specific medical definition in evidence, the Ninth Circuit is concerned that the phrase erratic behavior, quote, may cover a range of conduct that varies in frequency, duration, and character, end quote. Well, argued Mr. Uribe, what about the fact that a different Ninth Circuit panel granted a petition for review in Acevedo Granados v. Garland, episode 48, where the particular social group was, quote, El Salvadoran men with intellectual disabilities who exhibit erratic behavior, end quote. Yes, indeed. What about that? Well, the panel reads Acevedo narrowly to be more about the term intellectual disabilities, which is medically defined, and not to have been about the erratic behavior component of the definition. Unlike that case, Acevedo explained the Ninth Circuit, quote, "The agency here did not ignore clinical evidence and diagnoses in favor of a lay judgment. Instead, the problem was a lack of supporting evidence in the first place," end quote, that is, for the term erratic behavior. The court also distinguished some similar out-of-circuit precedent. The Ninth Circuit seems to recognize that this whole particular social group framework employed by the BIA can be a bit of a catch-22. After all, the phrase erratic behavior was only added to the particular social group definition in this case to limit the particular social group and make it particular and possibly socially distinct. But be careful, said the Ninth Circuit. Quote, "A component of a proposed social group can narrow the group while at the same time fail to provide clear boundaries for ascertaining who is a member of the group," end quote. Seems like a bit of an unworkable particular social group framework, no? That's what the Ninth Circuit believes happened here with the term erratic behavior, at least without an expert opinion or some other medical evidence defining that term in the record below. The court also affirmed the denial of Convention Against Torture protection. Too speculative, said the Ninth Circuit. Matter of JFF. Quote, "Mr. Uribe's first theory, that he will be tortured in a Mexican mental health facility, relies on the premise that he will not be able to obtain necessary mental health treatment in Mexico, and that without this treatment will be involuntarily committed in a facility where he will then be tortured. Because the allegations of torture rest on a hypothetical chain of events, cat relief cannot be granted unless each link in the chain is more likely than not to happen," end quote. The classic cat denial. Mr. Uribe, in fact, has some family in Mexico, and the court doesn't know whether he can, in fact, get mental health treatment in that country. Nor does the evidence of poor conditions in Mexico's mental health facilities compel the conclusion that Mr. Uribe will be specifically targeted with the specific intent to torture as the cat requires. That's reasoning that relies on the generally seminal Villegas v. Mukasey decision. But if you want a lot of good arguments to make to distinguish Villegas with Mexican mental health institutions in the Ninth Circuit, check out Guerra v. Barr, discussed on the podcast on episode 20. But yes, Villegas v. Mukasey is always going to be a difficult one to overcome in cases like this. Anyway, the court didn't see a cat claim based on the former gang membership or tattoos either. No real explanation why by the Ninth Circuit, other than the fact that Mr. Uribe hadn't connected the widespread cartel violence in Mexico to himself specifically. As the IJ and BIA considered all risks of torture in the aggregate, the Ninth Circuit affirmed the agency and the removal order against Mr. Uribe. And that is Uribe Andrade v. Garland. Which brings us to Amador-Morales v. Garland, published by the 8th Circuit on February 27th, 2024. This case is about that old podcast friend, motions to reopen, and deficient notices to appear. Mr. Morales is from Mexico, entered the United States without authorization in 2003, and was placed in removal proceedings 7 years later. He accepted voluntary departure and departed the United States in 2012. He returned without authorization a few months later in 2013. When caught in 2014, DHS served him with a new notice to appear and started removal proceedings all over again. Proceedings were continued many times for many years for counsel to investigate U visa eligibility. It appears Mr. Morales may have been the victim of a crime. All of this took us to 2019, by which time the Supreme Court had issued the Pereira decision, kicking off our wonderful world of deficient NTA litigation. Shortly after Pereira, Mr. Morales' attorney moved to terminate proceedings. Apparently, the NTA didn't have the date, time, or location of Mr. Morales' first hearing. As happened to so many of us during this time, the IJ denied that motion, reasoning that Pereira was simply about the stop time rule for cancellation of removal. The IJ then also granted DHS's motion to pre-termit Mr. Morales' application for cancellation of removal. Perhaps the IJ reasoned that the subsequent notice of hearing cured the NTA deficiency for the stop time rule purposes? That's wrong today, but it wasn't wrong back then under BIA and some circuit precedent. Looks like nothing happened with that U visa, by the way. Mr. Morales appealed to the BIA. The BIA affirmed. Then Mr. Morales filed a motion to reopen, which the BIA denied. Before the Eighth Circuit, Mr. Morales brought 3 arguments. The Eighth Circuit rejected them. Seems that matter of Fernandez, the BIA's now seminal deficient NTA decision, was published after the BIA dismissed Mr. Morales' appeal, but before it denied his motion to reopen. So I suspect matter of Fernandez might have been the basis for the motion to reopen. Mr. Morales argued, seemingly before the BIA and certainly before the Eighth Circuit, that matter of Fernandez was an intervening change of law that mandated reopening, particularly as it was directly contrary to some prior BIA precedent that governed during the proceedings before the IJ and likely even during his BIA appeal. The Eighth Circuit didn't quite see it that way, though. The Eighth Circuit read all of that pre-Fernandez BIA precedent as mostly about the jurisdictional implications of deficient NTAs. A deficient NTA does not divest the IJ of jurisdiction, and that's still true today. That a deficient NTA is violative of a mandatory claims processing rule kind of came out a bit later, first in the circuits and then trickled its way finally to the BIA in matter of Fernandez and maybe a few cases before that. For example, another BIA decision, matter of Nikifor, episode 113 of the podcast, held that raising a deficient NTA objection for the first time in a motion to reopen is not timely enough. All this meant to the Eighth Circuit that matter of Fernandez didn't directly overrule prior BIA precedent. Although I do believe that Fernandez, or maybe a prior case, put to rest the BIA's prior precedent that a follow-up notice of hearing made everything peachy. Undiscussed here and maybe not relevant. To the Eighth Circuit, then, and contrary to the Eighth Circuit's reading of the Fernandez dissent as well. Quote, matter of Fernandez was not an intervening change in the law that would excuse Mr. Morales' forfeiture of the objection to the NTA, end quote, below. And because it's not an intervening change of law in the Eighth Circuit, it's going to be a lot harder to argue that removal proceedings must be reopened relying on matter of Fernandez, based solely on an argument tethered to DHS's violation of a mandatory claims processing rule. Intervening changes of law are powerful things in the motion to reopen context, but Fernandez is not one, says the Eighth Circuit. It didn't matter to the Eighth Circuit that actually the IJ had mentioned later on that Mr. Morales had withdrawn his admissions and concessions to the charge of the NTA after Pereira was issued. And I'm not going to lie, I kind of got lost in the Eighth Circuit's rationale here, as to me it's a bit unclear what the IJ actually did on removability. Seems like maybe the IJ noted that counsel had withdrawn the admissions and concessions to the charges in the NTA, but that the IJ never affirmatively said that the admissions and concessions could be withdrawn, and then the IJ may have never definitively found removability otherwise established, other than through admissions and concessions? To the Eighth Circuit, that all meant that here, the admission and concession to the charges in the NTA was never actually withdrawn, making Mr. Morales' later objection to the NTA untimely as it occurred after the close of pleadings. Quote, absent egregious circumstances, a distinct and formal admission before, during, or even after a proceeding by an attorney acting in his professional capacity binds the client as a judicial admission, end quote, and explained the Eighth Circuit. Mr. Morales can't avoid this as he did not allege ineffective assistance of counsel. Remember all of this next time an immigration judge or DHS gets upset that you don't admit and concede to the charge in the NTA. Case law changes, and here's the Eighth Circuit holding counsel to an ambiguous admission and concession post-case law change to Mr. Morales' detriment. Moving on, though, Mr. Morales' motion to reopen with the BIA also requested a remand so that he could possibly negotiate prosecutorial discretion with DHS. The BIA denied that request, noting that it lacks authority to force DHS to grant PD, which is true, and the Eighth Circuit affirmed. Plus, and this is just me, nothing stops DHS from exercising its prosecutorial discretion in the motion to reopen context before the BIA without a remand. And it all meant that Mr. Morales lost his case. To the dissent! Judge Kelly dissented and implied that matter of Fernandez is a fundamental change of law. More central to Judge Kelly's dissent, the judge notes correctly that matter of Fernandez, quote, did not define the closing of pleadings, end quote. it did not definitively say when exactly a deficient NTA objection must be raised to be timely. Judge Kelly would send it back for the BIA to say when the close of pleadings actually occurs in removal proceedings, and believes some of the hard and fast rules laid out by the Eighth Circuit in this decision are, quote, not always how it works, end quote, in removal proceedings. Few things can be said to be. And that is Amador-Morales v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.